friends, welcome to the 269th session of Legal Empowerment through Interaction lecture series. The journey, the Holocaust ride has been wonderful. We have been exposed to different thoughts, ideas, which we agree, which we may not agree, but end of the day, we all went back home. Today, the topic is intellectual property litigation and its interface with competition law. The speaker is known to this platform. He had addressed us earlier. He's a wonderful speaker. Sai is a good friend, and thank you, Srikant, for again inviting him onto this platform. So I think it's befitting that the introductory remarks be given by Srikant. Srikant, over to you.
Thank you very much for giving me this particular pedestal to introduce Mr. Sai Deepak. Sai as he prefers to be addressed. I was quite intrigued that this particular topic was chosen, and my intrigue was for the fact that we have seen the speaker speak about a variety of topics, and this particular topic is probably a topic which is the least available in public platforms, possibly. So that being said, this topic has its own uniqueness with me as well, because of the fact that I operate in the jurisdiction which has a particular mandate to regulate antitrust arrangements between the parties, or antitrust arrangements between two entities, which will result in a dominant position, so to speak. And we look at India, which has got the CCI, the Competition Commission of India, which has got sweeping powers under Section 4 of the Competition Act to explore arrangements or agreements which have transpired between entities, with a small proviso in Section 4, which reads out that IP arrangements are not part of that particular inquisition that could be made by the CCI. Well, that being said, if I compare and contrast that with the functioning of the European Union, where 90% of the antitrust issues relating to intellectual property are situated, and if I may read Article 101 of the TFEU, in short, which prohibits arrangements or agreements between undertakings and decisions of associations of undertakings that prevent, restrict, or distort information within EU's single market. So the specific provision over there is regulated for the European Union, and it is for information as well as any arrangement which could happen, which could result in a dominant position. Now, that being said, the Indian position has been far more, I would say, on a balanced scale, where there could be legitimate expectations that could be set in terms of certain arrangements or agreements between the parties, in which a carve out of an intellectual property could happen so as to retain the commercial value of that intellectual property. For example, we saw the GMR case, which was inquisition by the CCI in 2019 or 2020. And then there were the decisions on the big tree, and especially in entertainment, where even for that particular matter, Book My Show was under the scanner from the CCI, where certain aspects were discussed about by the CCI in terms of whether the API which was used by Book My Show was quite unique, and it led to a dominant position. Now, this is quite in contrast with the sweeping powers that we find in the TFEU, as mentioned earlier, which did not have the proviso that we find in the Competition Act, and which had very, very significant Article 101 specific for the intellectual property. But if you see the number of instances where antitrust regulations have kicked in and have reached a multi-million-dollar settlement or a multi-billion-dollar, I would say, dispute, so to speak, in the European Union has been far more than it has been in India. But we are not talking so much about IP disputes in India or the essence of Competition Act in India and how these two are interplaying. And that is a wonderful topic that we need to talk about. The reason being, we are living in a world of intellectual property now. As we speak, this particular lecture or this particular speech is being transmitted in intellectual property, uh, uh, and it could be the intellectual property of an entity. It could be the intellectual property of the speaker. It could be intellectual property of the person who's commenting and the rebuttal which is happening, or the rebuttal which is happening for that particular comment, as may be attributed. We also live in the era of intellectual property which is tangible. The reason why I'm calling it tangible is it's a paradox in itself, which is we are talking about the COVID vaccine. There is a necessary input that goes to the COVID vaccine, and there has been instances where necessary input is claimed as a reasonable ground for a particular arrangement between the parties, which does not carry a intent of malice, so to speak. So that being said, I believe the intention is given much more weightage in India as compared to the other jurisdiction, which carry a weightage to the letter of law rather than the intent as to the arrangement between the parties. And I find it fascinating because IP itself is about intent. It's about the intent of one party being, or of one person being transmitted to other person and may be devolving into a product or may not be devolving into a product. So this being said, I find it quite intriguing, and who better to speak on this particular topic than Mr. Sai Deepak. Sai, who has been quite eloquent on various topics and who has been the author of a very, very popular book, which I'm led to understand is part of the necessary readings of many universities, if I'm not wrong. The last I checked was a notification which was issued by the university. And we are eagerly awaiting the series 2 of the trilogy, if I'm led to understand it right. And Sai is of immense value to India, Bharat as he calls it, and immense value to our platform. And over to you, Sai, for further.
Thank you so much.
Thank you, Srikant, for putting things in perspective, and the stage is all yours, Sai.
Thank you so much. Thank you so much, Mr. Shyam Padman and Mr. Srikant, Dr. Srikant, for the warm introduction. So I'll give a few prefatory remarks just so that the choice of the topic and where I come from becomes clear in terms of why do I wish to address this particular topic. So the fact is, prior to Sabarimala, I was known primarily for my strengths in intellectual property and competition law. These are my core areas. And over the years, what has happened over the last 3-4 years is that there are two parallel universes that I've had to straddle. The larger public believes that I practice only constitutional law. And the core fraternity has seen my transition from intellectual property to constitutional law and competition law on a regular basis. So on a daily basis, I've had to give clarifications as to why do I practice both, or how did I make the transition? I get emails regularly asking this question. So I thought, for a change, I will address a topic which goes back to my area of core competence and try and bring to bear my basic skills as far as these areas are concerned, and expose myself to the scrutiny of my own peers, and look forward to their own questions on the subject. Now, as far as the choice of IP and competition law is concerned, IP as a universe has its own set of rules. Competition law as a separate universe has its own set of rules. And when they two meet, how do we look at the issues that they throw about. Because one, on the face of it, you see a regime which grants a certain monopoly in return for a certain degree of disclosure. And on the other, you have a regime which tries to present the market and consumers with as many options as possible. So to a person who doesn't have a picture of how both of them interact, both of them they must come across as perhaps being an antithesis of each other. One must be seen as matter and the other is seen as antimatter. So the idea is to actually present why that relationship or that way of looking at it is flawed, and how they end up complementing each other, where intellectual property regime, if operated within the rules and within the realm of competition law, ends up presenting a greater basket of options to consumers, is one argument. And competition law, if exercised properly, will try and prevent abusive conduct on the part or anti-competitive conduct on the part of IP owners, and therefore again facilitate a greater set of options before customers. That is broadly the attempt that I'm going to endeavor as part of this particular discussion or interaction. I've stopped using the words lecture and talk or speech only for one reason, that I'm being told that it comes across as a top-down approach as opposed to being an interactive approach. So what we can perhaps do is during the course of the lecture itself, or rather the interaction itself, if at all someone has a question, in the flow itself, I would suggest that you ask me a question, because typically what I've noticed is a question ends up bringing out a better response as opposed to a monologue. So feel free to stop me during the course of the interaction itself, as opposed to waiting for the end of it, because an answer when given in the flow is much better than an afterthought after I'm done with what I have to share. So that would be my limited change as far as the format is concerned, subject to the consent of the organizers. So let's start with 2 or 3 basic outlines as far as intellectual property is concerned. I'll then explain how competition law works, or rather share my limited views on it, and then bring both together. Now, IP in itself is not a monolithic conduct, except for the fact that there is a certain degree of intangibility in a certain property, which is this object of protection across the board. Which is to say, as opposed to protecting what is visible, you're protecting something that is invisible, and therefore something that is mental or intellectual. That is the fundamental object behind it. So whether it's patents or copyright for that matter, even in copyright, while you're looking at protecting the text, you're trying to protect, as IP practitioners are aware, you're trying to also protect the broad representation of the feel that you get through a certain book, not just the exact language. So that's one. Then you have trademarks, which tries and protects the reputation that is associated with a certain brand, so that the quality or the expectation that consumers have of a certain brand is not free-ridden by someone else, and nobody tries to ride on its coattails. Then you're looking at geographical indications, which tries to protect anything that has a nexus with a particular territory, whether it's a manufactured product or an agricultural product or a natural product. So all 3 aspects are specifically covered under geographical indications. Then of course you have trade secrets, perhaps the oldest form of intellectual property, and the most well-recognized form of intellectual property as part of common law pool. And of course you have semiconductor design layout, which tries to protect a specific industry's contributions to semiconductor design. Then you have the Plant Variety Protection Act, which is specifically applicable in the realm of agriculture. These are the broad species of intellectual property as we know it. One of the, of course, emerging discussions as far as Bharat is concerned is data exclusivity, which I'll come to at a later stage, which may not be strictly relevant to this particular discussion. Now, what is the basic premise of intellectual property regime? The discussion starts from trade secrets simply because it functions on the premise that we will not give you any public protection because you have chosen to hoard that particular piece of information, and therefore your ability to protect that piece of information is entirely dependent on your means to protect its secrecy. If you can protect it as secret from the rest of the world, then it remains yours for eternity. But if somebody is able to rip it apart, which is to say you put out a product and somebody is able to reverse engineer that particular product, reverse engineering cannot be actioned against, which is to say third parties have the right to reverse engineer a product, even if it is protected by trade secrets, because reverse engineering is seen as a right of the public. If I have a product, I have the right to open it and see how it works. And if I'm able to understand how it fundamentally works, then I'm not stealing what is yours. I'm only reverse engineering what already exists in the public domain, thanks to the product that you've put out. Now, over the centuries, what had happened, at least about perhaps in the early 18th century, you started looking at a regime which effectively said, as opposed to trade secrets, let us come out with a regime wherein you reveal your information to the public, make it available to the public. Apart from the fact that you will be given credit for pioneering or inventing that particular idea or that particular technology, you will also be given a specific form of monopoly for a specific period. So the underlying quid pro quo between the public and the owner of that particular piece of information is, you give the information to the public for a limit with proper disclosures, and you enlarge the pool of knowledge that is available to the public. And in return, the public shall respect your right to that particular intellectual property for a very specific period. And during that period, nobody else will be allowed to replicate that particular idea on a commercial basis. This is the broad commercial transaction or the broad social contract which informs the intellectual property regime. Now, competition law or antitrust law significantly owes its evolution to the conduct of IP owners, or even non-IP owners for that matter, in the United States, where you had cartels developing over a point of time in certain industries, thereby them hijacking prices or availability of products or supply lines and whatnot. And therefore, the Sherman Act itself in the United States is a product of a significant degree of evolution, where I think the judiciary started recognizing that there is a form of conduct that needs to be recognized, which is unfair in nature. And therefore, the antecedent to competition law is the doctrine of unfair competition, significantly speaking, which has its roots to a significant extent in common law and then as applied in the United States to a very large extent. Now, once intellectual property regime achieved a certain degree of maturity, authorities realized, or regulatory authorities realized, that this is not only going to result in expansion of the pool of options available by way of increasing innovation, it is also going to result in a situation where IP owners will try and stifle others. Now, before I move to this particular area, since we are on the topic of competition, I think it's important to distinguish between two forms of competition that is recognized in economics. One is called static competition and the other is called dynamic competition. So assume for a moment, Dr. Srikant and I are both in the business of selling toothbrushes. And both of us come out with almost the same product, with almost the same features, with not too much of a difference in terms of functionality or look or whatever it is. The only thing that he and I are going to fight on significantly is the price point, which is to say who is going to be able to sell the product cheaper and thereby make it more affordable to the public and thereby increases market share. So static competition refers to a situation where you're not fighting on anything other than price. You're looking at supply, you're looking at economic controllables or variables, so to speak, as opposed to product-based controllables and variables. Dynamic competition is a situation where you alter the game completely, which is to say, why should I compete with Dr. Srikant Parathasarathy, or why should he compete with me on the same product? Let me make a better product and then increase two things. One, I force him to catch up with me, or he forces me to catch up with him. In the process, who benefits? The public benefits because there is a better option available at this point. So the entire premise of intellectual property is that you create a specific incentive to foster or enable dynamic competition with the intent and effect of increasing the basket of options available to the customer. That is the intent of intellectual property. So therefore, that brings in the nexus between competition and intellectual property. Intellectual property is believed to increase the rate of competition by presenting more options because it forces everybody else to come out with better products. Now, as opposed to doing this, should you choose to use your intellectual property right to prevent others from engaging in fair competition, that is when it results in anti-competitive conduct, which is to say, the weapon in your hand, which is meant to be a shield against appropriation by third parties, if it suddenly becomes a sword, where you use it primarily to stop other people from enlarging the scope of public options or consumer options, you have effectively indulged in an abusive conduct or an anti-competitive conduct. This is the nexus between intellectual property law and competition law. Now, there are two aspects that I have to clarify here, which are very, very important. Every intellectual property legislation, so to speak, has its own internal remedies to curb abusive practices. So there are two ways of addressing an abusive conduct on the part of an intellectual property owner. One is an option which is available within the IP legislation itself, and the other option is available outside the IP legislation, previously by way of the MRTP Act and now by the Competition Act. So why do you need internal mechanisms as well as external mechanisms? So let me explain that better. Those mechanisms which are available within the intellectual property legislations typically are by way of compulsory licensing mechanisms, which is to say, to go back to the example, assume for a moment, Dr. Srikant Parathasarathy has a patent over a specific form of brush, which makes it possible for you to reach the back end of your mouth in a better fashion. But Dr. Parathasarathy chooses not to come out with a product at all, not to use that product for the benefit of the customer. And because he's sitting on that particular invention with a patent under his ownership, a third party cannot enter that particular realm. This translates to IP hoarding for all practical purposes, which is to say, the basic expectation that you will make a product in return for an IP right being given to you and make the product available to the public, that basic contract is completely infringed, or you walk back on it by not coming out with a product but exclusively having intellectual property. In that sense, what you're doing is that you're under exploiting it and you're also not allowing others to use it. That is when a compulsory licensing mechanism typically becomes available, which is to say, should you choose to discharge the obligations which are cast upon you as an IP owner, then the law permits the regulatory authorities to identify another person who can step into your shoes as a compulsory licensee and discharge those obligations which you have failed to. Which is to say, I can make an application as a competitor to Dr. Parathasarathy and say, for 3 years, this gentleman has not used his patent. He has not come out with a single product. Or there are 1 lakh customers who deserve this particular product, but he's in a position to cater to only 20,000 people or even lesser. Therefore, he is not in a position to meet the requirements of the public. And therefore, I must be allowed to step into his shoes as the compulsory licensee so that I can fulfill the public's expectations with respect to this product. Why is it called a compulsory licensee or a compulsory license? Because Dr. Parathasarathy is not giving this license of his own volition. He doesn't want to give a license to me. Therefore, he is compelled to issue a license to me under the Act. Therefore, it becomes a compulsory license. This is a mechanism that is available across the board in events of non-use or in events of underuse or in events where your conduct is flagrantly against the restrictions imposed by the Act. Now, why is Competition Act then necessary when there are means available within the IP legislations to address this kind of conduct? Competition Act has an umbrella feel, or what I would call, without bringing in a religious reference, a Catholic feel, in the sense it is all encompassing. Competition law approaches an issue from a market perspective or an economic perspective. IP law looks at an issue primarily from the standpoint of exercise of rights and abuse of rights, not from an economic perspective. So the difference between an IP-oriented approach and a competition-oriented approach is that an IP approach is largely legal and statutory, whereas a competition-based approach is largely econometric and legal, and therefore it has a market-oriented analysis. If you have to compare the blend of economic analysis between intellectual property law and competition law, economics plays a greater role even in establishing legal conduct as far as competition law is concerned, because the test is whether a certain conduct has an appreciable adverse effect on the competition. That is the test. So let me draw a comparison here between two forms of, or rather two situations with respect to the same industry. All of us have phones, and take a look at the top right-hand corner of your phone. On the top right corner of your phone, you have 4G, 3G, 2G, E, Edge Plus, and whatnot. Now, this feature is commonly applicable to all phones, regardless of whose phone you buy, because this is a platform technology, which is to say, regardless of the independent strengths of your phone or weaknesses of your phone, the basic functionality it is expected to have is its ability to communicate with another phone. Whether it is a Nokia phone or not doesn't make a difference. Whether you're making a connection between an Airtel call or a Vodafone call shouldn't make a difference. So neither the difference in the brand of the phone or the telecom network operator should come in the way of this particular platform technology, because this technology is meant to facilitate interoperability. So maybe about 20-25 years ago, those who have traveled abroad, I did not, I'm just making a wild guess here, you wouldn't be able to use your Indian cellular phone outside. You wouldn't be able to use it in the United States, because the broad technology that they use and what we use are completely different. But over the years, the entire industry has moved towards what is known as interoperability. And therefore, there are technologies owned by private entities which facilitate interoperability. Now, what does this mean? Assume that Mr. Shyam Padman, Mr. Vijay, and Dr. Srikant Parathasarathy are three different mobile manufacturers. And I happen to be the entity that has come out with this platform technology. All three of them must buy my technology in order for the users to be able to speak with each other. Otherwise, they will not be able to talk with each other. Therefore, imagine the powerful position I am in, wherein every person in the mobile phone industry will necessarily have to secure a license from me because I have a patent over the platform technology, and none of these people can set up their business without taking a license from me. This is what is known as the mobile patent wars. Just Google it whenever possible. And the fight is about what is known as a standard essential patent, which is a technology which is essential for all to practice, is called an essential technology. And since it relates to technology standards that all of us have to comply with, it's called standard essential technology. A patent over a standard essential technology is called a standard essential patent. And therefore, for your own independent research at a later point of time, you're looking at SEP litigation, standard essential patent litigation. I've had the good fortune of being an advocate for multiple Indian entities on SEP litigation in its groundbreaking pioneering years of 2013, 2014, so on and so forth, and I continue to represent them in these matters. So this comes from a first-hand experience. So what happens is, assume for a moment I'm an Indian manufacturer. I don't have ownership over a patent with respect to these platform technologies. Dr. Parathasarathy happens to be the person who owns this particular technology. Whether I'm a Gioni or a Micromax or an Intex or a Nokia doesn't make a difference. I have to go to him and say, please give me a license. Otherwise, I will not be able to sell a phone. Now, knowing fully well that my business is dependent on his license, the negotiating power of Dr. Srikant Parathasarathy is higher because he is in a position to influence the market, whereas I am not in a position to influence the market. Because without Dr. Parathasarathy's technology, I can't launch a phone, and no one in the industry can launch a phone without his technology. This puts effectively Dr. Parathasarathy in a dominant position because he is in a position to influence the rest of the market without being influenced by the market. So if you take a look at the definition of dominance or the understanding of dominance under the Competition Act, it means you're the tallest person in the room and you're the broadest person in the room, and this room is slightly crowded. Your movement is going to affect everybody else, whereas everybody else's movement is not going to affect you as much. So you remain almost untouched and uninfluenced by market forces, whereas everybody else is being affected by market forces. So when an entity reaches a position where it is no more affected by market forces, it becomes what is known as a dominant entity, or a position, or an entity enjoying the position of dominance within the meaning of Section 4 of the Competition Act. Now, assume for a moment, Dr. Parathasarathy says, I'll give you a license. but you have to give me 25% of your profits. Now, what Dr. Parathasarathy is doing is he's literally milking me for everything that I'm worth, and I'll come down to the streets. Which is to say, he is effectively asking for a certain degree of profit, which makes it unsustainable for me to survive in the market. So then what is my remedy? As a licensee who wants to take a license from Dr. Parathasarathy, my only expectation is please be reasonable, because you're going to get your license fee not just from me, but from everybody else. The entire market is going to pay you for the very same technology because you own a market technology or a platform technology. Please be reasonable. He says, I'm sorry, go take a hike. These are my terms. Take it or leave it. If you don't take it, you're out of business. If you take it, you will be in business and still live, although you'll be bleeding for the rest of your life. So then what are the legal remedies available to me? My remedies can be either under the Patents Act or under the Competition Act. That is where the interface slowly begins. Which is to say, I can initiate proceedings under Chapter 16 of the Patents Act, which deals with compulsory licensing, starting from Section 83 onwards, which sets out general principles, and 84 and all that, basically accusing Dr. Parathasarathy of going beyond the reasonable expectations which he is entitled to have as a patentee under the Patents Act. Which is to say, you are expected to get a reasonable license. Nobody is stopping that. So you can ask me for perhaps 4% or 10%, but 25%, I'll be out of business, right? So I can say that he has violated specific obligations cast on him by the Patents Act and initiate or trigger a proceeding under the compulsory license regime of the Patents Act. I'm using the Patents Act as an illustrative example. Similar mechanisms are available under all IP legislations. But my remedy is not limited only to the Patents Act. I can then look at the Competition Act and say, not only is your conduct in violation of specific expectations under the Patents Act, you're also an abusive entity within the meaning of the Competition Act. Because you are in a position of dominance and you're literally creating what is known as an entry barrier. Or you're making it difficult for existing people to survive in the market. And in the process, you're reducing the options available to the customer. The vibrancy of the market is being single-handedly influenced in a detrimental fashion by Dr. Parathasarathy's conduct. So that is one way of going after him, which is to say, if you want a market-based allegation and a competition-based allegation, you go under the Competition Act. But if you have a patent-based allegation, you go under Chapter 16 of the Patents Act. Now, Dr. Parathasarathy can do one thing more. What can he do? He'll say, you know what? I am going to strike a distinction between Nokia and Intex. Nokia comes from a Western country. He's better. He's more sophisticated. Let me give him better terms. And I give him preferential treatment. And as far as you're concerned, well, you Indians don't have any patents. All you do is you steal from us. So let me give you worse terms. So he chooses to have preferential terms between two sets of players, both of whom are expected to operate in the same market, which means he is going to affect my competitive ability with respect to another competitor. The conduct of one entity and his negotiation with respect to two entities upsets the competitive balance between these two entities. So in addition to abusing his position of dominance, what he's also indulging in is preferential treatment within the meaning of Section 3, subsection 4 of the Competition Act. Now, Section 4 specifically applies if you happen to be in a dominant position. But assume for a moment that Dr. Parathasarathy doesn't satisfy the requirements of dominance, but he is still engaging in preferential treatment with respect to a third party that has an adverse effect on the competition. I can still go to the Competition Act and say, he may not be in a dominant position, but his preferential treatment has an extremely adverse effect on the competitiveness in the market. So what this means is, when you look at the conduct of an IP owner, you can look at it as the conduct of an IP owner, or you can look at it as the conduct of another market player. When you focus on the aspect of IP conduct, you go to legislations under or remedies under the IP Act. When you focus on the entity's behavior as, let's say, a player in the market who is distorting the market, you look at remedies under the Competition Act. Now, what is critical to note here from a jurisdictional perspective and from a legal perspective is these are not mutually exclusive remedies. These are alternate remedies, both of which can be exercised at the same time, which is to say, I can proceed against him asking for a compulsory license before the patent office and lodge an application saying, this gentleman, he has not satisfied so-and-so requirements of the Patents Act. Therefore, I need a license on following terms. I asked him for a license. He's asked me to take a hike. That's why I've come to you. Or he's asked me to secure a license, but on extraordinarily unreasonable terms. Therefore, I've come to you. The other option is to go to the Competition Act and basically say, his conduct fundamentally smacks of market arrogance, which translates to dominance under Section 4. Or he's indulging in preferential conduct, thereby distorting the entire market landscape. And therefore, his entire business practice needs to be looked at. So what does this tell you? An analysis under the Patents Act or an IP legislation is very specific. It has very specific boundary conditions. Its triggers are very, very specific. And the remedies are also very specific. But the Competition Act is like the supreme Brahmastra available. Of course, the standards that you have to satisfy to establish your case are also higher. But should you be able to do so, read Section 19, Section 21 and all that of the Competition Act, and you'll see the powers that the Competition Commission has been given is extraordinary, super extraordinary. No court in this country other than the Supreme Court under Article 141 has these kind of powers. Interestingly, the Supreme Court does not have inquisitorial powers. It is still an adversarial body. Whereas the Competition Commission is both inquisitorial as well as adversarial, which means the Competition Commission can take up an issue suo moto. If you take a look at Section 19(1) of the Competition Act, it can do so suo moto. It doesn't need someone approaching the Competition Commission saying, he's done this to me, she's done that to me. No. If the Competition Commission believes that in a particular sector or in a relevant market, there is an entity that is behaving in violation of Sections 3 or 4, or for that matter, even 6, because of a merger and all these issues, it is in a position to take up these issues on its own. Under the Patents Act or any IP legislation, no suo moto power is given to any IP authority to take cognizance of such matters. According to me, and I've said this before, the most powerful entity in the realm of market economics with extraordinarily superpowers, which is both underworked and underutilized in this country, is the Competition Commission. It can single-handedly set right quite a few market inequities. And therefore, this legislation must be understood in all its glory. And we have to ask ourselves, why is it that the Competition Act and its use doesn't find as much reference in Indian conditions? Why do we see only a couple of cases being filed every year? I'm not making this as a self-serving suggestion for lawyers. I'm basically saying that a legislation that has been brought about to set right market inequities is underutilized, in my opinion. I've seen this over the course of the last 5 to 6 years, having appeared before this particular forum across the board. I've seen that it is not done as much as it can do to set the balance right. So coming back to the central nature of the topic, the interface is this. Even if there are specific remedies, and here I'm trying to appeal to the lawyers in all the attendees, which is to say, when it comes to IP specific conduct, our standard argument could be, why should a general legislation prevail over a specific legislation? And on this particular subject, I'll recommend a few judgments for you to read. Please read the judgment of Justice Vibhu Bakru of 2015. This was the year before I went independent. This was delivered in the Ericsson case, where I happen to represent some of the informants, namely Intex and Micromax. This is a landmark judgment which effectively identifies the nature of interplay between IP legislations broadly and Patents Act on the one hand and Competition Act on the other. Now, this matter is before a division bench of the Delhi High Court. So please consider it for one reason. It is a fantastic decision which captures the law on everything that has happened in the Competition Act until that point. One, what is the nature of the Competition Commission? What is the nature of an IP right? How do both interplay? And how the Indian Competition Act is broader and wider in its ambit than even the TFU that Dr. Parathasarathy was referring to. Specifically, the court has come to the conclusion there that the ability of the Competition Commission to take cognizance of an abusive practice of a dominant entity under Section 4, subsection 2, subclause C of the Competition Act is wider than Article 104 of the TFU, saying here any practice which is abusive in nature, so long as the entity is dominant, can be brought within the ambit of scrutiny. So the Competition Act, I believe, is going to play a huge role in areas where you may not have other strictly legal or statutory remedies in that particular sense. You may have an access to a remedy under the Competition Act. One of the things that I think is beautiful about the competition legislation is that it's not as if it operates like a silo, saying I exist, the rest can go to hell. No, it has a fantastic provision which acts as a link provision between the Competition Act and other regulatory authorities. Let me give you an example. Assume for a moment that the Competition Commission believes, see, there is a conduct of a patentee. Although I have the specific and the broad power to go after the conduct of a patentee, I may want the opinion of the controller of patents on a specific issue so that I can factor that as part of my analysis, which is to say, please tell me whether you believe that this particular entity has satisfied its requirements under the Patents Act or not. You can take even that into account. You can also take into account the fact that what is the standard license rates which are offered in this particular realm. You can farm out that particular issue to the compulsory licensing authority under the Competition Act. So the best part about the Competition Act is that it effectively fosters what I call interactive regulation. It allows the Competition Commission to pick the brains of subject matter experts as well as domain specific regulators and factor the inputs from domain specific regulators to comment and come out with a market based opinion, a broader opinion. This, I think, is a seminal piece of legislation which effectively makes use of talent pools available in different areas. There's one more thing about the Competition Act. There are two provisions. In fact, three provisions that you must read together, section 60, 61, and 62 together. These three provisions effectively determine how the Competition Act is meant to interact with other legislations. On the one hand, it says, when you exercise the Competition Act, do so in a manner that it does not derogate against any other law, provided it is not in conflict. But should a conflict be established between any other legislation and the competition legislation, the Competition Act shall prevail, it shall have the overriding effect. So if there is a tussle between, let's say, an IP legislation and a competition legislation, then, or rather the Competition Act, then the Competition Act shall prevail is the categorical express language used by the Competition Act. Now, there is one important provision that I just read out for the benefit of the audience so that you understand that there is a direct provision that connects IP legislations with the Competition Act. So for your reference, you could consider taking a look at section 19, subsection 4 of the Competition Act. Now, section 19 effectively is, it captures how the Competition Commission could consider multiple factors as part of its analysis, both under section 3 and section 4. Now, section 3 deals with, rather section 19 subsection 3 deals with complaints or informations under section 3, and section 19.4 deals with complaints or information under section 4. 3 deals with anti-competitive agreements, 4 deals with issues of abusive dominance. So under 4, it sets out from A to M all the factors, or at least some of the factors that the Competition Commission may consider when asking itself whether a particular entity is in a position of dominance under section 4 or not. Now, I'll just read out section 19.4. The Commission, while inquiring whether an enterprise enjoys a dominant position or not under section 4, shall have regard to all or any of the following factors, namely market share, size and resources of the enterprise, economic power of the enterprise, including commercial advantages over competitors, vertical integration, dependence of consumers. Take a look at 19.4G. It says, monopoly or dominant position, whether acquired as a result of any statute or by virtue of being a government company or a public sector undertaking or otherwise. So the first portion says monopoly or dominant position acquired as a result of any statute, which is to say a statutory monopoly can form the basis of an entity acquiring a dominant position is clearly recognized under the Competition Act, thereby establishing that IP legislations which give statutory monopoly and Competition Act are meant to be read together. They are not to be read in isolation. That the Competition Act also takes into account the conduct of IP owners because they are owners of statutory monopoly is crystal clear from this particular provision. In addition to that, you should also take a look at two other documents. One is the Raghavan Committee report, which forms the basis of the Competition Act, where there is a specific portion on how, when it comes to even conduct of IP owners, independent of remedies available under the IP legislation, access to remedies under the Competition Act is specifically available, is mentioned in this report. I happen to have the opportunity of presenting these arguments before the Delhi High Court on this particular subject, and we cited all these reports. So you'll find the references to these reports along with the relevant extracts captured in the judgment of Justice Vibhu Bakru. Let me see if I can just share a link for the benefit of the audience. Just a second, please. I don't think there's a better tool available to most lawyers other than Indian Kanun. Yeah, so on 30th of March 2016, this is the judgment. I'll just share this. Please read this judgment. Fair disclosure, this is currently under appeal before the division bench of the Delhi High Court. It's coming up before Justice Rajiv Shankar and Justice Talwant Singh. It's up for arguments and hopefully it should be taken up soon, I think on the 27th of February. But whether you agree with the conclusions of this particular judgment or not, at the very least, it gives you a fantastic picture of the lay of the land and the broad play of issues. So this is one judgment that I think you should seriously read. I think this is the broad sum and substance of what I wanted to share with you. Why don't we open up the floor for questions? And with the questions, let me see if I can add further value, assuming I've added value.
Definitely. Srikant, you can take the lead.
Thank you. Thank you very much. I believe it is quite premature to thank you at this particular moment, Sai. I believe the audience has certain questions. Why don't I pass over the baton to them first, and then I have quite a few.
Sure.
Definitely, I have. You're muted, sir.
We have Srinivas. Srinivas, please unmute and shoot.
Sir, good morning, sir. I think it is good afternoon, sorry.
Good afternoon.
It's a very nice, nice lecture, sir. I would like to take a comment of you on this Monsanto cotton seed case, sir. So the Delhi High Court agreed with what you said. The CCI is having a absolute jurisdiction.
Correct.
But what about Supreme Court judgment?
Supreme Court judgment in what regard, sir? CCI versus Hill?
Overturn the judgment of High Court now?
No. So what has happened is the Monsanto batch of appeals and the Erickson batch of appeals are being taken up together. Okay.
Sir.
And so for that matter, the division bench of the Delhi High Court has also granted a stay on Justice Bakru's judgment. But you have to realize that Justice Bakru was the same person who gave the judgment both in the Monsanto case as well as the Erickson case. Okay. So the outcome couldn't have been any different because it was the same question of IP specific remedies available and competition remedies available. And therefore, at this point, both matters or both issues are before the before the division bench. So the Supreme Court has not taken a final verdict on this particular issue because otherwise then these appeals would not be pending. But both these matters will be taken up. So on the issue of Monsanto, without commenting too much on a matter which is listed along with my matter, the issue is the same. Whether the terms of the license under which these seeds were made available to farmers and the expectation that they must continue to buy these seats subsequently and all these issues, would they fall within the scope of the Patents Act, or would they fall within the scope of the Competition Act, or for that matter, the Plant Variety Act? These are aspects that the court is concerned with. So the issue is not done and dusted. It's not final yet, which is why I caveated my position by saying, read this judgment to understand arguments from both sides. I am in favor of the side which basically says you shall have access to both remedies. And if both remedies conflict, then the competition remedy effectively reigns supreme as a consequence of Section 62 of the Competition Act, is my position. But because I'm attached to a particular position, thanks to my representation, I could be wrong as well. That is for the court to ultimately decide.
Thank you.
We have a question from a doctor. Could you please identify yourself?
Sir, sir, it is Mohan Krishna, sir.
No,
Yeah,
sir.
please, go ahead.
Sir, the very lucid expression of the interplay between this and that. And I have some kind of a question, sir. How these standard essential patents and their role in balancing the interest of the dominance position as well as the IP rights of the right owner, and particularly the licensees. How you can fit these SCPs into this interplay part?
Right. If I may, sir, I think if you don't, I request you to kindly mute when I answer, if that's okay with you. Yes, thank you.
Okay, okay, please.
So there are two mechanisms available. In other jurisdictions, what they follow is a policy of what is known as FRAND, which is to say, let's assume that Mr. Vijay happens to be the owner of an SCP, a standard essential patent, and I happen to be a mobile manufacturer. Now, other jurisdictions, what they do, okay, let me take you back and give you a bit more of the background. So this is becoming like a Mahabharata, story within a story within a story. So let me try. So let's use three dramatis personae. Dr. Parathasarathy plays the role of an organization. Mr. Vijay plays the role of an IP owner, and I play the role of an Indian manufacturer. No biases here, but my complexion comes closest to be an Indian manufacturer. So, so Dr. Parathasarathy is playing the role of an organization known as a SSO, a standard setting organization. So how does this work? Now, world over, for all the mobile phones to function with each other and operate with each other, you need somebody that lays down the standards, just as you have the Bureau of Indian Standards in India, right? So you need a global standard. So you have an organization in Europe called the European Telecommunications Standards Institute, ETSI, which was previously the French Post and Telegraph Service. Okay. That organization acts as the nodal body for laying down of global telecommunication standards, technology standards. Whether you're Indian or whatnot, it's largely that body. So in different fields, you have different standard setting organizations. So for instance, I'm a mechanical engineer by training. So there is a body called American Society of Mechanical Engineers, ASME. So that establishes the standards for mechanical engineering. Otherwise, every tool that you use or implement you use will have different dimensions in different places. You will not be able to use it. From a drill bit to whatnot, you need standardization. Cars have specific dimensions within which they're supposed to operate. Whether it's an XUV or a compact SUV or whatever it is, these are based on specific dimensions, regulatory in nature, which are meant to facilitate common production lines, right? So therefore, in the realm of telecommunication, you have ETSI. Now, when you have ETSI, ETSI is like a senate or a parliament of all these stakeholders. You have right owners and you have licensees, which is to say people who have the rights and people who are implementers of those rights through their products. All of them participate. Now, when there is a technical problem, Nokia will have one solution, Samsung will have one solution, everybody will have different solutions. And every solution is protected by a patent because each of them believes that if my solution becomes the standard solution, I can milk the industry. You get what I'm saying? Assume for a moment that Mr. Vijay's solution is accepted as the best possible solution to meet a technical problem. I'll give you an example. Have you ever operated a walkie-talkie? When you operate a walkie-talkie, two people can't speak at the same time, which is why you need the over and out signal because it is a one-way channel. a walkie-talkie is a one-way communication channel, which means once you press the button, you speak and you say, I am done, and you shut up. Then the other person speaks and he says he is done and he shuts up. Okay. A mobile phone is a two-way communication channel, which is why you don't need to keep saying over and out, over and out. Second, over the mobile phone, assume for a moment that I'm on a conversation with my mother. When the person is silent, you have to create an artificial noise to show that the other person is on the line. Otherwise, you won't know that the other person is on the line. Sometimes you get the problem whether they are on the line or not. You end up asking this question because you get an artificial silence. You're not able to understand whether the other person exists or not. These are technical problems, and these are some of the smallest technical problems. There are massive technical problems which the industry has tried to address over the years. So when there is a problem, everybody will have different ways of attacking that problem. And when they find a way of solving the problem, they would want a monopoly over it, which translates to patent rights. So Mr. Vijay will say, this is my way of addressing the problem. Mr. Shyam Padman will say, this is my way of addressing the problem. Then the technical committee of the body, which is headed by Dr. Parathasarathy, the standard setting organization, will say, we have evaluated all of this. We have put it to vote. We come to the conclusion that Mr. Vijay's solution is the best possible solution. Okay. Now, when you're part of the standard setting body and you present your solution as the prospective standard to be applied across the board, you enter into an agreement called a FRAND agreement with the standard setting body, which is to say, if my solution is ultimately accepted as the standard, I will make my technology available to Sai Deepak and everybody else on fair, reasonable, and non-discriminatory terms. Okay. So therefore, you are making a promise to the standard setting body that I will conduct myself in a reasonable, fair, and transparent fashion if you make my technology the standard technology so that I do not discriminate against all of these people. Okay. Now, here's the legal question. This is a contract entered into by a private party with a non-Indian entity. What is its value under Indian law? Sunna, nothing. That agreement has no value in India. I'm not privy to that particular contract. At best, the SSO can sue this fellow for breach, or he can sue the other fellow for breach. How will we benefit? So therefore, what we have done in India is that the Department of Telecommunications has recognized ETSI standards as India's applicable standard, saying anybody who operates in this country will follow the technical standards. But our Department of Telecommunication has not said you will also abide by the FRAND obligations or the fair reasonable obligations. So therefore, our solution before the court was, even if there is no FRAND obligation in India or it is not legally applicable to India, they are expected to conduct themselves in a fair and reasonable manner, both under the Patents Act as well as under the Competition Act, which is to say, even if FRAND is not applicable in the legal regime of Bharat, there are two combined legislations that impose requirements of fairness, reasonableness, and transparency on a patentee, namely the Patents Act under Section 84 and the Competition Act under Sections 3 and Section 4. So these effectively operate as tempering levers on the abusive conduct or abusive propensity of a patentee. So that is exactly why you have these remedies available. So licensees have a legal expectation that licensors / patentees shall operate fairly and reasonably. I hope I've answered the question. This is the broad regime. So if you were to operate in Europe or you operate in America, you will typically look at FRAND because they have legally recognized FRAND. Their courts have recognized FRAND as the basis for licenses. India says FRAND or no FRAND, we have other FRANDs through our own legislations, namely the Patents Act and the Competition Act. So this is the remedy to effectively tell them, be reasonable, you will get the money through volumes as opposed to killing the goose at one go. So that's my answer. So I hope that is that addresses your question.
It's okay with you? I mean, you can unmute. Unmute.
I think you're on mute, sir.
Please unmute, sir.
I think Dr. Mohan Krishnan is on mute.
Okay. Yeah. Dr. Srinivas, please.
No, sir, I have done with my question.
Yeah.
Thank you.
Sir, I mean, you were.
No, let me go next then.
Yeah, please. I mean,
I believe in the interest of advocacy, Sai, if you could share, and please address me as Srikant. There's no need for an official reason as such. But what is a probable defense that one would have? There are legitimate expectations that could be met, but there could be legitimate apprehensions towards inventing as such. So I'm thinking as an inventor, and I'm putting myself in your shoes. I'm more of a I come from an accounting background. I'm not an engineer, so to speak.
Right.
But let's assume that there are inventions which are being carried out by the IITs, and why not by IITs, by any scientific institution.
Right.
And there is a enterprise which is basically stifling it.
Right.
It's an inverse scenario of what we are talking about. So let's say the compulsory licensing is being applied and so on and so forth, and a situation is being created where you're not dominant, but there are certain arrangements that you have engaged into in purely commercial terms, which are legitimate and expected out of a reasonable person.
Right.
So can that behavior be abusive, so to speak, and that behavior be condemned by the CCI? Right. And which is primarily the reason I believe the CCI is underutilized, because the apprehension that they may cast on a private individual against innovation is much higher than the apprehensions that they would cast against a particular enterprise which is willingly entering into any. There is a reasonable ground which is or a reasonable expectation that everything is being reasonable.
Right. So there is a balancing act that these legislations attempt. So let me answer the question from both perspectives. So assume for a moment, you and I are the licensor and licensee without patents. Okay. So we'll take two situations, one as a patentee and one as a non-patentee. Okay. If you as the licensee overreach the license and screw around with my rights, and you don't take my rights seriously, then there is a specific carve out under section 3 subsection 5 of the Competition Act, which says any reasonable measures that may be taken by a licensor who owns intellectual property in the interest of preserving his rights shall not come within the scope of an anti-competitive conduct. Which is to say, if your conduct is reasonable, you will sue him legally. You deprive him of access to technology the moment he starts violating the terms of the contract, and you ask for injunctive remedies. None of this is prescribed, which is to say, the Competition Act cannot take away your legal rights under IP legislations to go after someone for both breach of contract as well as for infringement of your rights. Because if a licensee violates the term of a contract or the obligations under contract, it gives rise to two counts. One is the violation of the contract or breach of contract, in addition to the consequential infringement of the right of the IP owner, both. One leading to the other. Therefore, there is a balancing act under the Competition Act itself, which protects this. Second, from a research perspective, if a private individual tries to stifle research activity of a scientific institution, or for that matter, even another private competitor, how do you balance this out? Now, the best part of any IP legislation, and specifically the Patents Act, is you have to take a look at two provisions. One is section 47 and the other is section 107A. Section 47 is the research exception. Nobody can be prevented from using even a patented invention for the purposes of research. Therefore, until it is ready for a commercial launch, or it is about to hit the market, or it has already hit the market, any activity that strictly qualifies as a research activity is protected under section 47. Second, in the context of pharmaceutical drugs, where it is extremely critical, because if you understand the way the pharmaceutical industry works, even if you have a patent or no patent, you first need the approval from the drug regulatory body, the DCGI, the Drug Controller General of India. That activity itself takes 3 to 4 years. So I'll try and address your argument in a very specific way. Let's assume Mr. Vijay is a multinational who owns this product called Apixaban, which is effectively used as a life-saving drug, or in fact, it's a lifestyle drug which deals with diabetics. Okay. Now, let's assume that patent is about to die on 28th of February, 2022. I, as the generic company, have the right to launch the product immediately after the patent expires, which is to say, the day the patent over Apixaban expires, any Indian entity for that matter has the right to launch the product saying, your patent is dead, you don't have a monopoly over it. So from the 1st of March 2022, I will launch the product. But I can't launch the product without regulatory approvals, right? And therefore, my activity on working on the product to generate regulatory information so that I can get the regulatory approval from the DCGI is exempt from an allegation of infringement under section 107A. So the first thing is research is also exempt from an act of allegation or from an allegation of infringement, sorry. And second, any activity undertaken for the purposes of regulatory information or generating regulatory data is also exempt from infringement. And the best part is, it's not only with respect to regulatory information that you have to submit to Indian authorities anywhere in the world. Why? Because India happens to be the bulk supplier of generic drugs to Africa. Okay. So we needed these protections to ensure that the Indian pharmaceutical generic industry's ability to supply the requirements of Indian patients as well as African patients is not diluted. That is precisely why you needed these exceptions. In fact, as a point of information, when we decided to come out with product patents in 2005 for the very first time in the realm of pharmaceutical industries and chemical industries, African nations frantically called India to say, you are the only country that supplies affordable drugs to us. If you come out with product patents on pharmaceutical substances, how will we address our issues? Because we were supplying HIV/AIDS cocktails to Africa because they couldn't afford drugs coming from Europe and America. We were the ones to actually do it. Therefore, to preserve the Indian generic industry's ability to supply all these demands, we decided to give an exception saying anything that is done either for research or for the purposes of regulatory approval shall not come in the way of, or shall not be accused of infringement. That means I can start my regulatory work from 2018 itself. And by the time the product expires on the 28th of February, 2022, I can have the regulatory approval in place. And the moment the patent expires, the next day I can launch the product. That is the standard operating procedure. So this is how there are balancing provisions from both perspectives within IP legislations as well as under the Competition Act. In fact, I've written a detailed paper on this, which preceded or which was around the same time as Justice Bakru's judgment based on what I felt was right. You will find this on the Indian Journal of Intellectual Property Law of Nalsar. I'll just share this just a second. It's fairly Googleable. It's one of the top results you get when you search for my name. Here it is. Yeah. I'll just share this piece. Where I've listed all aspects possible on the interface in terms of jurisdictions and all that. I'll just share this piece. Competition law. I'll just share this. I'm not able to get this. I'm getting my previous article, but not this one. Patents, competition. Yeah, patents and competition law. Sorry, this is for NLS Bangalore. I'll just share this. Yeah. You may want to read this whenever you have the time because I've discussed the practical aspects and advocacy aspects in detail here. So this is the link to the article. And
you are shared in the chat box?
Yes, sir, in the chat box, sir.
It's not come on. So we
It's not come out.
It's not,
even,
maybe
even
because,
the earlier one didn't come on, sir.
Yes.
oh, is it because it's, oh, I think I'm sending this to Mr. Kamath as a direct message. I'm so sorry.
Yeah.
So I'll make it to everyone, is it? Yeah.
Yeah,
yes,
that's better. I mean, we
So-
belong to everyone.
So I hope now you've got it, the NLS link.
Yeah, we
Yes.
got it. Yeah, wonderful.
And I'll share the Erickson judgment also.
Very good. Yeah, very good.
Yeah.
Yeah, we got both. Yeah.
Okay, done. So that's the answer to your question, Srikantji.
And can I have Prashant Murthy? Prashant, please go ahead.
Yes, yes, sir. Thank you, Mr. Sai Deepak, for your enlightening lecture. My name is Prashant Murthy. I'm an advocate from Bangalore. So my question is, in your opinion, does the current legislative framework address this issue of interplay between the patents and the, or let's say, intellectual property rights and the competition law? Or if there is a lacunae, sir, what is it that should be addressed by the legislature? And is there a particular framework from any other jurisdiction that we can probably proceed towards? Or should we wait for judicial dictas?
So the provisions that I was referring to make my point of interactive regulation is Section 21 and Section 21A of the Competition Act. Okay. Now 21 is by a statutory authority to the Competition Commission. 21A is a reference by the Competition Commission to statutory authority. Okay. So this two-way interaction is facilitated by the Competition Act. So I'll just read this out for the court's, I mean, for the court's benefit.
And no fees being paid.
A matter of habit. I'm so sorry. So, in fact, whether it's on debates or arguments in home, it has become a standard practice to call it submission. So
No, this is in fact a code. No issues.
yeah. So reference by statutory authority, where in the course of a proceeding before any statutory authority, look at the language, an issue is raised by any party that any decision, everywhere it says any, showing who can do this, which such authority has taken or proposes to take, is or would be contrary to any provisions of the Act, then such statutory authority may make a reference in respect of such issue to the Commission, which is to say, should you believe that you're running into a collision course with the Competition Act, any statutory authority can raise any issue and refer that matter to the Competition Commission. Now, therefore, the question arises, which is, can a court which is seized of an infringement proceeding qualify as a statutory authority for the purposes of reference under Section 21 to refer an issue to the Competition Commission? Which is to say, if a court which is seized of a strictly statutory proceeding or legal proceeding for infringement comes to the conclusion that the issues that have arisen before it have a competitive, let's say, complication or a consequence, so to speak, would a court qualify as a statutory authority? Now, in this case, I would say that courts are statutory authorities in some senses. It could be argued both ways, that statutory authority is not, does not encompass within it courts, but I would find it extremely difficult to make that argument. Now, let us see whether statutory authority is defined. I'm so sorry, there's nobody in the office. Let me just shut that phone and come. Just a second.
2W, sorry, yes. In the meantime, let me read out. Statutory authority means any authority, board, corporation, council, institute, university, or any other body corporate established under any central, state, or provincial act for the purposes of regulating production or supply of goods or provision of any other services of the market thereof, or any matter connected therewith or incidental thereto. Sai, I've just, since you were not available, I just read out.
Yeah. So going by this, a court doesn't fall within this particular definition.
Yes.
Because it says any authority, board, corporation, council, but it doesn't stop there, established by or under, for what? For the purposes of regulating production of supply of goods or provision of any services and markets thereto, or any matter connected therewith or incidental thereto. Is it possible to speak of incidental thereto? No, because courts incidentally also don't perform this particular function, right?
Indeed.
But other than courts, any other body which wants to ask for this particular reference can do so. Then take a look at Section 21A. reference by commission, where in the course of a proceeding before the commission, an issue is raised by any party that any decision which the commission has taken during such proceeding or proposes to take is or would be contrary to any provision of this act, whose implementation is entrusted to a statutory authority, then the commission. Which means to say, somebody might make an argument, your general competition jurisdiction doesn't apply to a sector specific regulation because there's a separate regulator for it. For instance, this argument was raised in the context of the Telecom Regulatory Authority, TRAI. So while you read these judgments on IP versus this, also read the other side with respect to TRAI, which went from the Bombay High Court to the Supreme Court. So both these judgments warrant reading. Now, the reason why you can't compare both that particular scenario and this scenario, because it's apple versus oranges, because the question is of what do each of the independent legislations provide. Telecom Regulatory Authority specifically is the regulator from market perspective for telecom bodies. That is not the position given to IP regulators. IP regulators are not market regulators. They are right regulators.
Yes.
Right?
Yes.
So which is why, so during the course of argument before the Delhi High Court, the Bombay High Court's judgment and the Supreme Court's judgment with respect to telecom has been cited against Justice Bakru's judgment to make the argument. While they have come to the conclusion, how can you come to this conclusion? Our argument is that conclusion is based on the specific language of the Telecom Act, where the TRAI has been set up, where there is a specific regulator that has been created for a certain sector. That's not the position with respect to the controller of patents. The controller of patents is not a regulator of patents. He is a giver of patent or destroyer of patent. He is not the regulator of patents in that particular sense, or he is not the regulator of market. Okay. He may be regulator of patents, but not regulator of market. Whereas TRAI is a regulator of the telecom market itself, there being a distinction. So that is the distinction that we have struck. So to answer your question, there is a to and fro possible. The suggestion that I would certainly make is the breadth of section 21 can be improved so that even if a court wants to refer something to competition, and I'll give you an example why. There is a judgment of Justice Endlaw in the matter of a copyright case. Justice Rajiv Sahai Endlaw of the Delhi High Court, who retired. Yeah. In the context of a copyright case, I think an anti-piracy case involving Microsoft or one of these software entities, where the defendant tried to raise the argument of unfair competition or anti-competitive behavior within the meaning of the Competition Act as part of his written statement in a suit for copyright infringement. But you understand that copyright is a statutory act thanks to Section 31. Yes. And therefore, rights and remedies are both governed only by the Copyright Act. And if a competitive remedy or an anti-competitive remedy doesn't exist within the Copyright Act, you can't raise this as a defense. So there he has taken the clear position, and according to me, the right position. You have a competition problem, go to the Competition Act. You can't raise this as a defense before a court, which leads to my suggestion that where a court believes that there is also an anti-competitive element involved as part of the issue, it must have the power to refer that particular issue to the Competition Commission and bring it to the Competition Commission's notice. That is absent in the current language of Section 21.
I believe one aspect which is incidental there too, Sai Ji, since you referred to me as Srikant Ji. Statutory authority can also be, let's loosen up the language. And we are talking about courts. What about arbitral institutions or arbitrators who are sitting on matters which have a competitive element, so to speak, and they have been set up particularly for determining issues of infringement of contract between the parties, which will give rise to IP rights between the parties.
Right.
So are they performing the duties of a statutory authority insofar as that particular obligation is concerned, is the question.
The problem is, this word statutory authority, there are two words. So when it says any authority, would a tribunal fall within the scope of that? But you see, the definition has two parts. One, it says, what is the purpose of the particular body? It says purposes of regulating production or supply of goods or provision of any services or markets, therefore, or any matter connected therewith or incidental thereto. An arbitral tribunal, which is the creature of consent between two parties, is not a body that has been established by any state or central legislation or provincial act. It's not a direct appointment under the Arbitration Act. It is an appointment through the Arbitration Act, but not under the Arbitration Act or by the Arbitration Act. Therefore, an arbitral tribunal strictly cannot fall within the scope of the definition of statutory authority. Coupled with the fact, then the argument would be any arbitration that deals with production of services will effectively go before the Competition Commission, or the tribunal will have the power to refer that matter there, which I don't think that's the case. Perhaps this happens to be a situation where, assume for a moment that you're the Food Corporation of India, FCI, okay, or for that matter, any public sector undertaking, or a private sector undertaking which has stepped into the shoes of a public sector by way of delegation of a sovereign function. And therefore, it has a bearing on matters of supply of goods and services. That perhaps may fall within the definition of a statutory body for the purposes of this particular definition. So courts and tribunals at this point, or at least arbitral tribunals, may not fall within that particular definition.
Wonderful. Before I go for the concluding remarks from Vijay, can I have K. Vijay Rao sir for your remarks?
Hi, good afternoon, everybody.
Good afternoon, sir.
I have been following you for quite some time, and it's nice to hear from you. I mean, yeah, sorry?
You have been stalking him.
No, sir. Actually, to be very honest, I got connected with him because he was challenging government interference in temples. And like I said, I've been one of the victims, so I used to keep following him on that. The link was sent by my brother from London. So he's saying, you follow this gentleman and you will come to know where we stand. That's one. But today's topic was really interesting, Sai, because understanding the market, the competition market and the regulatory market are two separate aspects. And you brought both of them together under one roof, thanks to this platform. It was really, I mean, you dealt with, I think, most questions. I mean, even the questions asked were few. The reason was you dealt with most of the subjects so lucidly that not much questioning could come out because most of it was understood. And the way you said that you were addressing some issues before the Delhi High Court. I mean, it's nice when people come out and say what is being done and why it is being done. Not everybody gets this platform to hear it out, and it was really nice having you. And thanks once again for taking the time, and thanks Sam sir for this beautiful platform and all the others who recommended Sai to us. And like I said, Sai, I've been following you because I have issues with the endowment department of Andhra Pradesh. So that's where I come from.
Right.
And I'll be having it again next week because I am from the founder member of the Pattisima temple.
I see.
Which is very famous, and we are having issues with the endowments at this point of time. Okay. Because they introduced a committee without even consulting us.
Right.
So we've challenged that. We've managed to get interim relief from the Honorable High Court in Andhra Pradesh.
The other issue that I was recently made aware of was how the state has abruptly and summarily brought down the number of members in the Dharmika Parishad, and the appointments are being made entirely by the state. I think so. That issue was brought to my attention by good friend Umesh Chandra. So I will be coming to Hyderabad on the 26th and 27th for a couple of, let's call them social engagements.
Oh, and, okay. Unfortunately, I'm in Bombay, Sai, and 25th I'll be landing into Vizag, and I'll be in Vizag for a couple of days.
Okay.
And this temple is come down from the Chola dynasty. It has got mentioned in the Vedas also.
I see.
The Swayambhu Shivling temple. So that's how. And then we were fighting. I mean, my father fought it for practically 30 years to streamline himself and get things into place. We had left the place. I mean, we were the erstwhile zamindars of Polvaram.
Okay.
And that's how the temple came into our fold from the Chola dynasty. My father left home for certain family reasons, settled in Bombay. Then after he retired, he went back and he spent 30 years of his retirement streamlining that temple.
Okay.
And down, I don't want to let what he has done down. So I've taken it up, even though reluctantly. My brother, who is in London, is very religious, unlike me. So he follows it more. I mean, not unlike me as sense. The thing is, I can't read and write Telugu. So that's my biggest handicap. So when you go there, I know. So that's the issue.
Rao sir, you can the assistance of Vijay as well.
Yes, yeah. No, I tried meeting him last time I was, but unfortunately he was in Hyderabad. I'll try and meet him this time when I go back. I make it a point to send a message to Vijay whenever I'm in that part. So I did say that. So first is Shivratri, so I will be there for that function. So that's how. Anyways, thanks. I mean, we digress from the subject, but thanks a lot for this platform.
Thank you. I mean, should I say Rao sir or Rao ji? Because we have been a lot of.
Sir, Rao is more than enough, sir.
Saying that. But I mean, I'd say that when we come to the end of the 269th session, can I request Vijay, please?
Thank you, Shyam. It's been a pleasure hearing Sai on a topic which we didn't hear him so far on any of those YouTubes. It's the other side or the livelihood side of the Sai. Yeah, Sai, it was fantastic, absolutely fantastic. You were, you didn't give too many scope for any questions. You were absolutely authoritative in every aspect with regard to patents and the Competition Commission. I can't say anything more but to say thank you. But before I conclude, I have always entertained this doubt with regard to patents vis-a-vis the life-saving drugs. How far they are from the moralistic point of view, how far they are good, or from the scientific point of view, is it better to continue with patents with reference to life-saving drugs? Because vis-a-vis the fundamental right of life.
So the thing is, on this issue, it is unfortunate that India cannot take an independent decision. We are bound by certain international frameworks. The TRIPS agreement, there is one. The second thing is, we were given a certain long rope until 2005 because we were called as LDCs, or we called ourselves as least developed countries when the Marrakesh Treaty was being discussed in 94-95. That is what ultimately led to TRIPS. And we got 95 to 2005 to set our house in order. By that, I mean that we had to bring it at par with others. And 2005, effectively, they said, we have waited long enough. And under TRIPS, no specific form of technology or sector or industry can be discriminated against. And if patents are available to everybody else, it should be equally available here. So to buffer that and to offset the impact of that, subsequently, what was called the Doha Declaration was entered into. So the Doha Declaration is what effectively preserves the rights of countries like ours to preserve our public interest goals, our public health goals, and also strike a balance between the rights of others. Because let's be honest, for some of these diseases, our homegrown industries are still not in a position to come out with blockbuster drugs. Because you see, development of a drug, whether artificially the price has been inflated or whether that is the reality, I don't know. It takes anywhere between 600 million to 700 million at the very least in the US. So if India is able to do something about it, I think that might really help. But here is where perhaps I go back to my Indic side, which is that certain aspects of health issues have to be addressed by your traditional medicinal systems. That is what China has been doing, which is when it comes to addressing all the primary issues as opposed to tertiary problems, at least let the basic issues be addressed by your primary systems, which is why the Ayush Ministry was set up. Okay, so that you get a fillip to each of these sectors, so to speak, across the board. Unfortunately, the proof of any, let's say, initiative is, in the crunch time, do you trust that particular system or not? During Corona, India was perhaps the only country to downplay its own homegrown systems. Whereas full play was given to Southeast Asian medicinal systems in Southeast Asia. China was doing this. The person who creates the virus trusts his system, whereas we who are the sufferers don't trust our system. And we insulted our Ayurveda practitioners by basically saying, whatever you say will be corroborated, will have to be corroborated by an allopathic practitioner. The other way around would not have been possible because the Indian Medical Association would have been up in arms. Okay, so it starts from that. Your approach to perhaps healthcare needs to be slightly more realistic in terms of Bharat's conditions. And then you have a broad policy. Because you see, patents is obviously not the silver bullet under any circumstances. So there are alternatives that are being discussed in this particular sector, which is, can we have a price-based mechanism or a subsidy-based mechanism to offset the cost of invention, as opposed to constantly paying them for 20 years, during which period their conduct can never be controlled. Okay, or rarely is it controlled. So that discussion is going on, but the life cycle of these discussions is such that for about 10 to 15 years, you develop a charter and a chorus. And then there is a critical mass that it acquires before it becomes a policy. From a policy, for it to become a law, you'll take another 5 to 10 years. So at least a 30-35 year cycle, not before that. And people have started asking questions about the viability of the patent system seriously. Basically saying, at least in the realm of life cycle, let's say life-saving drugs, don't you think your conduct is being, let's say, unreasonable? As someone who represents all the Hyderabad-based generic companies, as well as Gujarat and Bombay-based generic companies, I know for a fact how the conduct is. I can give you fact by fact, patent by patent, drug by drug, disease by disease, how they've behaved. But of course, I'll be accused of bias and professional lobbying as a lawyer. So I do believe that your point is seriously valid. This is where state power effectively becomes very critical. If the state chooses to flex its muscle and uses all the TRIPS flexibilities available, and also couples it with its own homegrown medicinal systems, even if you cannot completely control their behavior, you can reduce the common person's dependence on that particular system to a significant extent, thereby bringing them down to their knees. If you take away the cold act or the chest on or the aspirin or whatever it is, and you make Ayurveda or let's say Ayush systems as the primary port of call, then your dependence on these aspects are gone. Because you have to realize tertiary drugs and tertiary treatment is only the upper creamy layer. That's not where the money comes from. The money comes from what I call FMCG medicinal drugs.
Right.
Fast moving consumer goods, which you keep popping on a regular basis like Dolo. Okay. Right. That's where the money is. Whether there is a patent or not, that's where the money is. Reduce the dependence to a significant extent, the bottom line starts hurting, then they'll say, okay, what do you want us to do? Then we can say, behave.
I agree with you, Sai. I mean, I have one at home. She was working for Merck.
Absolutely, but the only issue is that I won't agree with Sai unless it comes from the West.
Yeah. No, we have, Shyam sir, basically we have portrayed an image. We have portrayed an image as though we are third world countries.
Absolutely, absolutely.
Like we have taught the world. I will give you a simple example. IT, India is the top. But can you believe it, when first computerization came into Air India, my servers were in Greece.
Sir, no, Mr. Rao, you didn't follow what Shyam was saying.
No, and the West has to ratify.
No, he was referring to the Glen River in Scotland.
No, let's not ignore the fact that most of these drugs have their pharmaceutical base in biology. For example, butterfly pea is the biggest, has the highest proportion of paracetamol in it as compared to any other plant. So it's got a biological. I believe there has to be a separation that has to be done between.
Srikant, the issue is when you're sick, what would you prefer?
No,
Let us forget about the world. Let us forget about the entire universe.
I'm coming to it. I'm coming to it.
What do you call Tulasi and other things? I don't.
Maybe I'm coming to it. I believe the port of call that Saiji is probably alluding to is the fact that we are not able to distinguish between biology and Ayurveda. This is the fundamental flaw in our understanding, at least. Because we necessarily associate biology with Ayurveda and Ayurveda with not a primary form of care or a primary administration of medicine, so to speak, or primary input for medicine.
We are not. On that topic, not to get into any controversy. When homeopathy is disowned by the country of its origin, and at least 4 or 5 countries have completely, said that it's unscientific. Kerala, I don't know about the other states, we have colleges where you give certificates, where you have courses and you become homeopathic persons. Is it part of population control or something else?
No, there is. These are all recognized. All these Ayurveda colleges are there everywhere.
No, I'm not on Ayurveda. On the other side. Let us not get into this controversy. It's a subject we may have to.
In one line in Telugu, it is called Amma Bhojanam Pettadu Adukun Kuda Tennavadu. It is that you don't feed us and you don't let us beg also. You see, so that is the whole situation. The problem is, if I diminish my own stature, why would you respect me?
Correct.
Why would you respect me?
Absolutely.
And unfortunately, what happened is in our fight, I mean, I'm not getting religious or thing, between the Ayurveda, the Unani and the other sects, we are fighting amongst ourselves for supremacy.
Sir, let us leave the magic remedies and so-called. The remedies. Forgive me for the using the term magic. But on the topic today, I'd say whether it's intellectual property or whether it's competition. Competition is challenging each other.
Correct.
I would like to wind up today by saying that let us never cease to challenge our intellect. Keep on challenging it. In the sense like there are no frontiers.
Very true.
Every day, every time when we have a speaker, Sai, really thankful to you for exposing us to these things in the sense like when you trigger a thought, it has to have different repercussions. Positive, negative, I don't know, good, bad or ugly, I'm not concerned. But end of the day, you make things, persons think. Things happen, persons think, and that's the beauty of this platform. With this, say voice words, I'd say, which I can attribute to myself.
No, carry on. I think we need to acknowledge Sai and for his
absolutely. A Sunday morning spilling out to the afternoon, well spent in the sense like that's where Vijay and to a certain extent even Rouser said that we have been categorizing persons to certain things, but no. These are avenues wherein we'll have to expose ourselves to different ideas and thoughts, and we'll be able to empower ourselves. Agree, disagree, but end of the day, we go home empowered. Thank you very much, Sai, for this wonderful exposition on this topic and the combination or the nuances of these two, one competition as well as intellectual property. It was indeed wonderful. And do be part of this platform.
Sure,
you're part of the family. Be here. And that's not just a request, but a requirement aspect.
Shyam,
thank you.
Generally, I don't take notes, but today I was making notes.
Same here. When you learn something new, it's good to take notes, Vijay sir.
Yes. Thank you. Thank you very much.
Wonderful. Thanks, Sai. So, thank you very much, Sai.
Till we meet again next week, please do take care and stay safe.
Namaste.